Arizona has a landlord-friendly breaking lease framework with a clearly codified duty to mitigate and specific statutory provisions that provide more structure than many states. The governing law is found in the Arizona Residential Landlord and Tenant Act, Arizona Revised Statutes. Title 33, Chapter 10, which addresses the landlord's obligations when a tenant vacates early and the tenant's liability for breach. If you're a landlord or tenant in Arizona, the ARLTA provides a clear and workable framework. Let's start with the landlord's duty to mitigate damages. Under Arizona Revised Statutes, Section 33-1370, when a tenant abandons the property or breaks the lease, the landlord has a statutory duty to make reasonable efforts to re-rent the unit. Arizona's mitigation requirement is codified. The landlord cannot leave the unit vacant and hold the departing tenant liable for the full remaining rent without making genuine re-rental efforts. The landlord must take reasonable steps: advertising, showing, and accepting a qualified applicant. The departing tenant's liability is limited to rent during the vacancy period, plus the landlord's reasonable re-rental costs. If the landlord fails to mitigate, the departing tenant's liability is reduced by the rent the landlord could have collected through reasonable efforts. Arizona's statute also addresses the calculation of the landlord's damages. Under Section 33-1370, the landlord may recover unpaid rent for the remaining lease term, but reduced by the rent the landlord collects or could have collected from a replacement tenant through reasonable mitigation. The landlord can also recover reasonable costs of re-renting, advertising, cleaning, make-ready work. Early termination clauses are generally enforceable in Arizona. The state does not cap early termination fees. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months rent is typical and enforceable under Arizona contract law. Arizona courts generally enforce reasonable contractual provisions and give deference to negotiated terms. Arizona does have a specific requirement regarding non-refundable fees. Under Section 33-1321, any non-refundable fee must be clearly identified as non-refundable in writing before being collected. If an early termination fee is structured as a non-refundable charge, this disclosure requirement applies. Failure to disclose the non-refundable nature can result in the fee being treated as refundable. Many Arizona landlords, particularly large apartment communities in the Phoenix metro, include detailed early termination provisions that offer the tenant a structured buyout option. A typical provision might allow the tenant to terminate with 60 days' notice by paying a fee equal to 2 months' rent plus forfeiting the security deposit, or some variation. These buyout structures are generally enforceable and give both parties certainty. Military members have the right to break a lease under the SCRA. Arizona has a significant military population. Fort Huachuca near Sierra Vista, the Army's Intelligence Training Center, Davis-Monthan Air Force Base in Tucson, Luke Air Force Base in the western Phoenix metro, Marine Corps Air Station Yuma, and the Yuma Proving Ground all generate military rental demand. SCRA lease terminations are regular occurrences across Arizona's military communities. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. Luke AFB's pilot training mission creates relatively high turnover as training classes rotate through. Fort Huachuca's intelligence training generates constant turnover. Davis-Monthan and MCS Yuma have more standard rotation cycles. Landlords near any Arizona installation should have streamlined SCRA procedures. Arizona has enacted protections for victims of domestic violence that allow early lease termination. Under Arizona Revised Statutes, Section 33-1318, a tenant who is a victim of domestic violence, as defined in ARS Section 13-3601, can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation must include a copy of a valid order of protection or a written report from a law enforcement agency documenting the domestic violence. the tenant must provide at least 30 days written notice, or may request an earlier termination date if remaining poses an immediate threat to safety. When a domestic violence victim terminates under Section 33, 1318, the tenant is responsible for rent through the termination date, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee. The security deposit is handled according to standard rules, returned within 14 business days. Arizona's provision addresses co-tenants. If the victim and the perpetrator are both on the lease, the victim can terminate their individual obligation. The remaining tenant's obligations continue, and the landlord can pursue enforcement against the remaining tenant. Arizona's provision also includes a lock change right. The victim tenant can request that the landlord change the locks, and the landlord must comply within a reasonable time. The cost of the lock change can be charged to the tenant. Tenants in Arizona may break a lease if the landlord fails to maintain habitable conditions. Under ARS Section 33, Chapter 1324, the landlord has a duty to comply with applicable building and housing codes, make repairs necessary to keep the premises fit and habitable, maintain essential systems, and keep common areas safe. If the landlord fails to maintain the property, the tenant has remedies under Section 33, 1361. The tenant must provide written notice identifying the deficiency. For non-emergency conditions, the landlord has 10 days to make repairs after receiving notice, with an additional 5 days if the landlord makes a good faith effort but needs more time. If the landlord fails to act within the statutory period, the tenant may terminate the lease. For emergency conditions that pose an immediate threat to health and safety, failed heating during cold nights, gas leaks, sewage backups, structural failure, the landlord must respond more quickly. If the landlord fails to address an emergency condition, the tenant may terminate immediately or take other remedial action. Arizona's notice and cure requirements are specific. The tenant must provide written notice, delivered in the manner specified by the lease or the statute. The landlord has the statutory repair period. If the landlord fails to act, the tenant provides a termination notice. Following this sequence precisely is important. Deviating from the statutory process weakens the tenant's position. Arizona also recognizes constructive eviction. If the landlord's failure to maintain the property or affirmative actions, shutting off utilities, changing locks without authorization, removing essential fixtures, render the unit uninhabitable, the tenant can treat the lease as terminated. Arizona has detailed abandonment provisions under Section 33, 1370. If a tenant abandons the property, the landlord can retake possession after following specific procedures. The landlord must provide notice to the tenant, at least 10 days for a month-to-month tenancy or 5 days for a week-to-week tenancy, before treating the property as abandoned. If the tenant's personal property is left behind, the landlord must follow the procedures under Section 33, 1370 for handling abandoned property, including providing notice and allowing the tenant to retrieve items before disposal. Arizona's abandonment provisions are more detailed than many states, providing landlords with a clear statutory process. Following the process precisely is important because improper handling of abandonment can create liability for the landlord. Arizona's medical marijuana provision is relevant to the breaking lease context. Under ARS Section 36.2813, a registered qualifying medical marijuana patient cannot be denied any right or privilege, including housing, solely for their cardholder status. If a tenant breaks a lease and the landlord attempts to retain the security deposit or pursue additional damages based on the tenant's medical marijuana use, this provision creates a defense. Landlords cannot claim marijuana use as a lease violation that justifies additional damages when the tenant is a registered medical marijuana patient using within their authorization. From a practical standpoint, Arizona has one of the largest and most dynamic rental markets in the western United States. Phoenix is the dominant market, the 5th largest city in the country. The Phoenix Metro, including Mesa, Chandler, Scottsdale, Tempe, Gilbert, Glendale, Peoria, and Surprise, has experienced explosive growth driven by technology, healthcare, aerospace, and in-migration from higher-cost states. When a tenant breaks a lease in the Phoenix Metro, re-rental is typically quick, 2 to 4 weeks in desirable areas, often faster during peak season. The Phoenix market experienced some of the most dramatic rent increases in the country during the recent growth period, followed by moderation as new construction added supply. But demand remains strong, and broken leases are generally absorbed quickly. Scottsdale commands premium rents with strong demand. Tempe, home to Arizona State University, has a tight market. ASU's massive enrollment creates enormous student demand. Lease breaks during spring and summer fill rapidly. Mid-semester breaks take longer. Chandler and Gilbert have attracted tech workers. Intel's fabrication facility and TSMC's semiconductor campus generate well-compensated demand. Mesa offers a range of price points across a large geographic area. Tucson has a more affordable market driven by the University of Arizona, healthcare, Davis-Monthan, AFB, and tourism. When a tenant breaks a lease in Tucson, re-rental is moderate, 2 to 4 weeks in desirable areas. Tucson's source of income protections, the only local source of income ordinance in Arizona, may affect screening of replacement tenants within the city. Flagstaff, home to NAU, has a tight market with limited supply. Lease breaks in Flagstaff are absorbed quickly given the persistent demand. Sierra Vista, near Fort Huachuca, has a military-driven market where SCRA terminations are constant. Yuma, near MKS Yuma, has a similar military dynamic. Prescott and Sedona have retirement and tourism-driven markets. Lake Havasu City has a moderate market. One best practice for Arizona landlords include a clear early termination clause that complies with the ARLTA's requirements, including the non-refundable fee disclosure under Section 33-1321. If your early termination fee is non-refundable, state that clearly in writing before collecting it. A well-structured clause with 60 days notice and a fee of 1 to 2 months rent provides certainty for both parties. Another best practice, follow Arizona's specific abandonment procedures under Section 33 of 1370 precisely. The statute provides detailed requirements for notice, timelines, and handling of personal property. Cutting corners on the abandonment process can create liability, even when the tenant clearly abandoned. A third best practice, begin re-rental efforts immediately and document every step. Arizona's statutory mitigation duty under Section 33 Fund 1370 is clear and enforceable. In Arizona's strong markets, you can typically minimize vacancy, but documentation of your efforts is essential for establishing the departing tenant's actual liability. Arizona limits the security deposit to 1.5 months' rent. The deposit must be returned within 14 business days of the tenant vacating. If the landlord fails to return the deposit within 14 business days, the landlord may be liable for up to twice the amount wrongfully withheld. These rules apply to broken leases and normal move-outs alike. The 14 business day clock starts when the tenant vacates. For the complete guide to Arizona breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.